This case is State of Ohio, City of Barberton v. Tristine Boychi. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please introduce yourselves, stay behind the podium, keep your voices up. You should not use the names of children or minors or victims or such. Should that be relevant to your argument, you can refer to those individuals by initials or generic terms like the child. We have read your briefs and we are ready to proceed when you are. And I would just ask, would you like to reserve time?
Thank you, Your Honor. Louis Grube here on behalf of defendant appellant Tristine Boychi. I'd like to reserve 3 minutes for rebuttal, please.
Very well, then you may proceed when you are ready.
May it please the court. Tristine Boychi was involved in 5 incidents in August of 2022 with his dogs getting loose, and we are here today to discuss 3 assignments of error we've raised. Given the state's concessions with respect to assignment of error 2, I'm not going to get into that issue. That would be the instruction on a question of fact and the jury interrogatories, which are generally not appropriate in a criminal case in Ohio. Instead, this morning I'm going to focus on the first assignment of error, sufficiency of the evidence, and the third assignment of error, the plain error admission of other bad acts evidence. Obviously, in the briefing was a little choppy in this case. I was not actually aware of the Jones case until we received the state's brief and saw, oh, well, under their theory of the law here, we actually still have a sufficiency issue with respect to the first 4 fourth-degree misdemeanors that Mr. Boychi was charged with and ultimately convicted of. So we pivoted a little bit in our reply. Under the state's theory, though, they still did not offer sufficient evidence of dangerousness or nuisance with respect to either of the dogs until, at the earliest, the 5th of these incidents. Now, the key fact here is that not until the August 12th incident, there were incidents on August 5th, 9th, 12th, 17th, and July 30th. So not until the August 9th incident did anyone involved in this case whatsoever offer any testimony, any fact relating to menacing conduct by any of the dogs. So August 9th is the starting point. That's the first date on which one of the dogs, and it was the black dog, which I'm going to assume that's the dog named Dozer. That's the first date that the black dog acted in any sort of menacing way. It's the first specific date that we have.
And these are all cases that Mr. Boychi, correct, am I saying Mr. Boychi?
Yes, Your Honor, I believe that's the right.
That Mr. Boychi was on trial for all these 5 cases at the same time. Am I saying that correct?
Yes.
The reference to judicial notice is some previous cases he had.
Yeah.
That never been found guilty.
Right, there were 5 previous cases, and the state has asked the court to take judicial notice that these were actual convictions relating to nuisance or dangerousness. Not only do the documents that were admitted not actually support that inference or even permit that inference, courts do not take judicial notice.
Well, and you're not wanting to address that, I may ask a question about later, but sticking to where you are now.
Yes, Your Honor. So
you have these 5 cases he's on trial for.
Even assuming these 5 prior cases, there's no evidence that those were nuisance or dangerousness, there's no evidence of menacing conduct, biting, anything like that, right? So we get to August 9th, that's the first date where anyone involved testifies.
But if he's not convicted of these cases prior to the trial, can they be used for enhancement under any circumstances?
Can you ask the question again?
I guess I'm confused. So you're saying Mr. Boychi's on trial for 5 matters on these different dates, and I appreciate that. But he's not been convicted of any of them as of yet. Can they be used for enhancing? So if I was there on 3 DUIs and we tried the same day, could you say, well, the first 2 are used to enhance the third and haven't been convicted yet? Do they have to be convicted first before they can be used for enhancement?
No, in theory, no. But I want to be careful to caveat. I'm not conceding anything with respect to the first 4 incidents here. So if you look at the Jones case that the state relied on, this is 2019-Ohio-5159. In the Jones case, that was a dog bite case. But the Supreme Court of Ohio still reversed finding insufficient evidence of dangerousness. And the reason they said that is because the statutes related to dangerousness refer to prior conduct of the dog. And so you don't commit this 4th-degree misdemeanor until there's been at least 1 incident of prior dangerous dog conduct before the incident that is charged as a 4th-degree misdemeanor. So that's the key here. The five incidents stand as they are as factual matters under Jones. We conceded that in our reply and pivoted to the state's theory of how the law applies here. So under that theory, the first incident where there was any evidence of dangerousness or nuisance conduct was this August 9th date, where Officer Howell, she didn't turn on her body camera, so we don't have any video, but she testified that the black dog walked toward her aggressively, but in a defensive posture. So that's the first incident where anybody testified that on a specific date, this dog acted in a specific way that would satisfy any of the elements of nuisance or dangerousness. And that's key.
And that would just make nuisance, right, not dangerous if walked up and
Yeah, so
with a person?
nuisance is like menacing, growling conduct, something that would be sufficient to make somebody feel in danger. The other events prior to that you can look at on the body camera videos. State's Exhibit 1, in the video labeled Boychi 1 on July 30th, the dogs approached the officers with tails wagging. Everybody's sort of interacting around the dogs as they mill about. On August 5th, when officers arrive, the black dog was barking in Boychi's yard, but it was in Boychi's yard and didn't approach anybody, and the white dog was in its enclosure. So only on August 9th did somebody say that the dog had approached them aggressively in this sort of menacing fashion in a way that would reasonably permit someone to fear danger in any way. So then, on August 12th, there was evidence that the dogs were off the property. There's not evidence about which dog it was. There's no video footage showing either dog. And Officer Robert Wanger testified that one of the dogs had been barking on Boychi's porch. Again, hanging out on the porch, on the property. So not doing anything nuisance off the property. Then, on August 17th, finally, there was a black dog in body camera view only briefly, and the white dog was taken to the house without incident. That's on video of Boychi 2. That's the first day where a dog that had previously been seen committing any sort of like menacing, nuisance-type conduct was actually seen off the property. And that's the point. You need this prior fact of nuisance and dangerousness, and then you need the dog off the property fact. And only when those two facts can join do you actually have this fourth-degree misdemeanor offense. And that would be for the first time on August 17th. So while we pivoted from our original argument that there was this prior designation, obviously the state found some case law that we're stuck with and that doesn't require that. We still require prior facts, and that's why in the Jones case, when the dog allegedly bit a neighbor, that was the first evidence that the dog had done anything, either dangerousness or nuisance. And so there was not sufficient evidence to prove a fourth-degree misdemeanor in that case under those facts, because there's no proof the dog had done anything like that before. That's the key. So I'd like to reserve any extra time on that for rebuttal and just go straight to the third assignment of error. So other bad acts. If you look at the state's brief, they're conceding essentially that these are strict liability offenses. It doesn't matter what Mr. Boychi knew, it doesn't matter what he thought, it doesn't matter why he was doing this, whether he was consciously doing it, whether it was an accident, whether the dogs were getting out on their own, whether he was doing everything in his power to keep them on the property. That actually, if he had been doing everything in his power, and I think there's some reasonable debate about that, if he had been doing everything in his power to keep them on the property, that still goes to whether the enclosure they were in was sufficient. It doesn't go to any sort of mental state, anything like that. So there's no fact they need to prove about what he thinks, what he feels, how he's feeling in the moment. So there's essentially, I always go back to Old Chief on 404B, on the other bad acts, right? Old Chief is Justice Souter's long opinion about how we balance the need for other acts evidence. But the basic starting point is that you need to have some purpose for this evidence. And without that purpose, there's no overriding need to admit it when it would allow for some sort of character inference or some other bad impermissible inference, something that isn't just a straight up fair inference from fact to an element. So in this case, there's no reason why they need to know what he thinks about his dogs getting loose, how he feels about it. They don't need to know that he, for example, there was testimony that he said that he wanted to shoot his dogs, he was so mad at them. And I can't imagine a more prejudicial thing to tell to a jury that somebody's so callous that they'd be willing to shoot their own dog because they're so mad that they're getting off the property. I can't imagine what the jurors must have been thinking about this guy in the room. And it's the court's, in a trial court, it's the court's job to try to make sure that nothing unfair like that happens, that jurors aren't going to make...
That doesn't somehow go to whether the dog's a nuisance or dangerous dog, what his belief is regarding the dog, arguably?
I mean, I don't know how, the dog's conduct, that he was fed up with them, I don't see that inference. I mean, it's, what the dogs did is fairly evident from other facts, and also I don't think that his subjective views, his feelings about his dogs permit any indication that they had been menacing or bit anybody or attacked anybody. I mean, I don't see that inference. I don't think that's a fair inference, and it doesn't logically follow. But even if it did, I mean, let's talk about this. It's a balancing test, right? So what's the purpose for that? Isn't there better evidence of that? I mean, we have video of the dogs, so why do you need this additional fact when the fact of nuisance or dangerousness is so readily proven with other evidence? And that's what Justice Souter said, basically. You know, we're not supposed to take the 404B evidence and put it on an island, isolate it, and assess whether it's more likely to prove a fact than it is to permit an unfair inference. What we do is we look at the evidentiary alternatives and compare them. So the state here had testimony from police officers about the dogs, they had the neighbors' testimony about the dogs, and they had video of what the dogs did on some of, at least most of these dates. So why do they need that additional inference from this subjective feeling that he had that could permit such a terrible character inference for the jurors? I mean, even if there were some use for it, under these circumstances where there's ample other evidence, there's no purpose for it to be admitted. And you know, the fact that he knew about all these other times that they were, you know, the fact that this dog kept getting off the leash, kept getting out of the house, I mean, without any evidence of prior nuisance or dangerousness, and nobody testified about that. The police officers just said, we know this guy, this is a consistent problem. The question is whether the dog had been a nuisance or dangerous on a prior incident, not whether it had gotten off the property on a prior incident. So that's the key. The fact that the police officers knew that this was a problem, that these were problem dogs, that really doesn't aid anything that was at issue. There's no factive consequence that it goes to. And then the swearing at the neighbor. I mean, again, I think we all have neighbors here, right? If you've ever had a hard interaction with a neighbor, you know that tempers can be flying, people get upset, they're living in close quarters. I mean, I hope none of us are held to account for that if it's not directly an element of a crime. And certainly there's no element of these crimes that you must also be in an antagonistic relationship with your neighbor. So I don't know why that came in at all. It doesn't permit any inference of any relevant facts, and it does permit a character inference that my client's a bad guy, and maybe his dogs are dangerous because he's so bad. So with that, I reserve the rest of the time. I mean, if there's any questions, I'm happy to answer them, but I'd like to save my 3 minutes, 20 seconds.
Good morning. Attorney Jen Roberts on behalf of the Save Ohio City of Barberton. I'm here to argue the Tristine Boychi matter. I will first start by indicating that the state never conceded anything in the brief. The state rested on prior arguments as the various assignments of error were alleging similar incidents. Rather than respond exactly how I responded previously, the state stated in their brief that we would rely upon the arguments made in the previous assignment of error with respect to that assignment of error. So we didn't concede anything. I want to start by saying that. With respect to appellant's assignment of errors, the designation that the dog be dangerous before trial is specifically addressed in State v. Jones, which indicates that there's no prior requirement the dog be dangerous, that the jury, in this case, can determine whether the dog was a dangerous dog by reviewing the statute. The statute defines, which the appellant's brief sort of omits. They say dangerous dog means without provocation, the subject today does any of the following: caused injury other than killing or serious injury to any person or killed another dog. They forget to put subsection 3, which says been subject of a third or subsequent violation of Division C of Section 95522 of the Ohio Revised Code. So in their brief, they omit that throughout its entirety. A dog is dangerous if it has been the subject of 3 or subsequent violations. It doesn't say convictions, it says violations of 95522. In this case, there was evidence presented that appellant had 5 prior convictions. And I'm going to address the judgment tree. In the appellant's reply brief, they say the state wasn't prepared with the evidence. No, the state was prepared with evidence. The state had certified copies of the judgment entry of conviction. When that judgment entry of conviction was reviewed, it didn't have anything on it besides a case number. So then the state got certified redacted copies of the docket to show that it was Mr. Boychi in that case number and what the charge was, and that he was convicted of the charge.
Were those admitted as exhibits? The second thing you're discussing, that it had his name on it and the charge?
So they were not. When we were at the trial court, there was an objection made to the certified redacted copies of the docket. And the trial judge indicated to defense counsel that one of two things were going to happen. They were going to admit that, or he was going to take judicial notice and instruct the jury that the convictions were, in fact, of 9522 and that Tristine Boychi was the person charged. This is the 5 prior convictions where he had pled, were pled to prior to, they were pled at arraignment, sorry. Pled at arraignment. And when that happens, there's just a stamp done in the docket and on the court file. And the state has no control over what that judgment entry looks like. What the state tried
Does the
to,
record reflect at least that you actually had that day the second document you would need, for want of a better way of saying it, to show exactly what it was Mr. Boychi and he was convicted of X?
yeah, so there was arguments made when they were opposing the admission of those documents, that the documents were there readily to be admitted. The judge just said, you pick.
Right, I saw that part of the transcript. The judge said, you pick, are we going to admit these, or are we going to take, or am I going to take judicial notice? As I recall, they said, we're objecting either way, so the judge said, fine, I'll take judicial notice.
Correct. So
And that's how we got where we got. Those things did not come in.
they did not come in, but not because the state didn't ask them to come in.
Well, something came in. What came in was am I correct in saying what came in was the first exhibit that didn't have his name and the charge?
Correct, Your Honor. So what came in was a certified copy of the front jacket. That's what the court uses when they do the pleas at arraignment, and that came in. And then in addition to that, the trial court judge took judicial notice of the fact that those were in fact convictions for dangerous, or dog at large, 9522, and that Tristine Boychi was the defendant in those cases.
Does
So-
the judge have the authority to take judicial notice of matters in a separate case?
So, in the reply brief, Your Honor, the appellant argues that the court can't take judicial notice of what is a required fact for the state to prove. The state has to prove there's a prior conviction. That was proved through the certified judgment entry, which would have also been proved through the certified redacted copy of the docket, which was readily available to be admitted. It would have been my preference for the trial court to just admit over objection the certified copy of the redacted docket. That's not what the trial court did. The trial court chose to take judicial notice. I do not believe that the trial court committed error when the trial court did that. I believe that they were simply rectifying their own judgment entry through judicial notice, that it was all readily available in that file. So I do not believe that there was error. What we argued in our brief is, if that was in error, there was certified copies of the redacted docket that proved Mr. Boychi was the individual charged with and had pled guilty to prior convictions.
But those aren't before us in the record.
Correct.
Okay, that's fine.
Yeah.
But make sure I understand that. You're saying these things exist, but there's no way I can go to the record and say, yes, here they are, I see they exist.
No, because they weren't admitted into the
I just want
evidence.
to make sure I properly understood that.
Yeah.
I am secondly somewhat confused about, it seems to me from your brief, that's the main thing you're arguing. We have these prior convictions, therefore, the statute's met. And the appellant's arguing, no, forget about all of that. Let's get into all this, what happened with all these charges that day, and eventually maybe one was good and 4. Are you also alternatively arguing that if we throw all those out, we still can find all these cases and look at them based on Jones?
I would in fact argue that in the alternative, although again, not conceding that the prior entries weren't sufficient and that the court improperly took judicial notice. I believe that that was properly done. But if you read 9511, it just says that the individual be the subject of third or subsequent violations. It doesn't indicate that those violations have to be convictions. We had five pending that day. So I believe that even if the court finds that there was error, although I'm arguing there is not, that there is still sufficient evidence for 2, actually 3. So third or more would be elevated to the M4. So after the first 2, because those would count, there would still be sufficient evidence presented because there's other dog at larges that the jury found that he had sufficient evidence. So we would argue in the alternative, yes. I'm gonna briefly touch on the bad acts. So I'm gonna start by talking about the testimony from the neighbor about the swearing. If you review the transcript, and I stated in my brief, appellant's counsel asked the neighbor, well, why didn't you just go tell your neighbor the dog was getting out? Why did you continue to call the police? Actually didn't ask why. They asked, did you? Did you approach your neighbor and tell your neighbor the dog was getting out? And her answer to that was no. They didn't follow up with that. So on redirect, the state follows up with, well, why didn't you? It was a simple question of, well, why didn't you tell him? I mean, I didn't know why she didn't tell him. I hadn't planned on asking her if she did or didn't tell the neighbor because I don't think it was relevant. But when the appellate counsel asked her, why didn't you tell, that's a question the jury's gonna be like, well, gee, why didn't she just go tell her neighbor that the dog was getting out? Why is she calling the police and doing that to get the police involved? And so, you know, that testimony was as a direct door opening from appellant's counsel about her telling the neighbor if the, why, you know, asking, did she tell the neighbor if the dog
Was there an
out?
objection when that question was asked by the defense?
I don't believe so, no. And also, with respect to, the part of the video where he says he wants to shoot the dog, there was no motion in limine filed prior to the trial, excluding that portion of the video. The state played the video, in its entirety because no motion in limine was ever filed to exclude any of the testimony from the video. So, I mean, the state played the video and asked questions based upon the video. No motions were ever filed. With respect to whether or not that was so prejudicial, I don't believe that it is a factor really even to be majorly considered. It was just in the body cam footage about, you know, what he had said about the dogs. But I do think it's probative, because he's admitting in that statement that he knows that the dogs are getting out again and again and again and again, and he's still telling them, well, I did this and I did that, and they're just being left in this, the testimony, they're left in this outside enclosure. I mean, he has a house. The testimony wasn't that the dogs were in the house and they were gnawing the doors open and getting out. He was leaving them in an enclosure outside. So I do think it is probative for the jury to hear that he was well aware that these dogs were getting out and menacing the neighborhood, quite frankly. There's a lot of conversations from appellant about nuisance. That is not in the slightest bit. I didn't talk about nuisance. I didn't argue the dog was a nuisance. This case is, this is a dangerous dog because he has 3 prior convictions, and by being a dangerous dog because he has 3 prior convictions, it is a misdemeanor of the 4th degree, which elevated it.
And the court instruct on nuisance?
I didn't review the court's jury instructions before coming in here today. I apologize. I'm not sure.
So are you, if I understand you though, you're today saying, I'm not here arguing the dog's a nuisance, I'm here arguing the dog's a dangerous dog.
Correct.
And if you don't find the dog a dangerous dog, well then you'd have to send it back because I'm not arguing nuisance.
Yeah, I never argued. I mean, our thing had always been the dog's a dangerous dog because he had 3 prior convictions of a dog at large, which by statute makes him a dangerous dog, which by statute elevates it to the misdemeanor of the 4th degree.
And I think that, from what I could understand from the record, is a more fair argument of what you were arguing for trial court. You argued this questions of dangerousness and not nuisance so much.
Yes, I'm not changing what I argued at trial court. That's what I argued at trial court. I don't know when I read the appellant's brief where the whole issue of all the focus on nuisance came. They were arguing at the trial court that he wasn't declared, the dogs weren't declared to be nuisance dogs, but that was never what the state was leaning on. The state was leaning on the provision of 3 prior convictions by statute to find the dog.
3 prior convictions, again, it's prior convictions, that would go to the earlier cases. You're saying violation is the correct language.
Yeah, and I just messed up. It does say violation, not convictions in the statute. So, appellate counsel also argued that there wasn't testimony about which dogs were out on which occasion, and that's not accurate at all. Each and every officer testified that every time they responded, the black dog was always at large. Sometimes the white one would also be out, but not always. So there was testimony at the trial court that each and every time that the officers arrived, the black dog was a violator, if you will. So that wasn't necessarily an accurate recitation. think that that is all that I wanted to say today. If there's no other questions, I would rest.
Thank you, Council. Hearing none.
Okay, thank you.
Thank you. I've got a few things to run through here. So, just cleaning up a few things. Motion in limine about the videos. The videos were turned over at the last second, the night prior to trial. I don't know how anybody could write a motion in limine after reviewing the videos that quickly, and also when they were
Did
turned
you
over.
move to continue if you got them right before the trial to say, I need a continuance to review these?
My client was entitled to a speedy trial. He was not obligated to waive anything in order to get
I'm
this
not
salary.
obligated to, but you have the right, a choice to make. I'd like to continue to have more time, or I'll try the case as it is today.
I mean, if a defendant has to choose between his rights, perhaps, but I don't think that's the law. He's entitled to have everything and to a speedy trial.
Did you object to those being given to you late?
Yes, there was an objection. We did not raise the Brady issue, although it was raised at trial. These were turned over at the last second. They were placed in a public building the night before trial. They were in lockup overnight, and the defense counsel did not have time to go get them the day before because she was given notice that, like, I think it was like 3 o'clock and the building closed at 5. So it's a pretty quick turnaround here. At minimum,
You're not objecting today to the delayed submission of that?
we declined to raise an assignment of error on that, so. On the state not objecting to the question, did you tell? Did you tell? Answer, no. That doesn't permit a character inference. Why didn't you tell? Because my neighbor's not very nice to me all the time. That does permit a character inference. And at minimum, the court, when dealing with these objections, could have offered a limiting instruction to the jury, didn't do that.
Did you
Declined to.
request one?
I mean, the objection deserves the
You either
issue.
did or didn't. I mean,
I don't recall.
Make sure I understand the record completely. Did you ask for an instruction?
I can't tell you the answer to that from the record right now. I don't have that answer.
Okay.
But there was an objection, the issue is preserved. For the Jones alternative argument, the court was very, very, very clear that you cannot establish the 4th degree misdemeanor using the same conduct from one incident. So that sequential 1, 2, 3, 4, then the 5th incident, that argument is rooted completely in Jones. We cited 2 cases, Goreski and Lovejoy, about how judicial notice is not proper to fill a gap in the state's case. That's true here. That's true in the trial court below. So if the court is saying, okay, 3 prior violations of the statute, where did those prior violations come from? Did they come from the 5 journal entries that should never have been admitted? Because that's the gap there. And then when we get to the 1, 2, 3 sequence, on the 4th day there was no evidence that I guess there might have been evidence. Ms. Smith, the neighbor, might have testified that the dog was in her yard. So even then, like, if the court wants to say 3 prior violations, still then the first 3 are off the table, only the 4th and 5th. So if the court decides to accept that argument that it's 3 prior violations rather than 3 prior convictions, we still have 3 4th degree misdemeanors that never should have been more than a minor misdemeanor.
If we decide that the court erred in admitting the prior convictions and not get into these events at trial for that day, is there any way, and I think you just touched on this a bit, is there any way for us to separate how the jury made the decision? Did they rely upon these 5 previous convictions or this activity? In other words, if we find the court erred in admitting this evidence, we have to remand it because we can't determine what they used to determine it was enough.
That's a very nuanced question. The way that I would answer it is that the sufficiency issue needs to be resolved before this court considers sending anything back for a retrial. So when you've decided that, if you've decided there was some error in admission of something was not fair evidence that could have been considered by the jurors, the court should run through the sufficiency analysis first, see if anything's left, because the prerequisite to a second trial or retrial is that there's no double jeopardy bar. So if the first 3 or the first 4 4th degree misdemeanors are reversed and minor misdemeanor convictions are entered by this court, then only the 4th or 5th incident should be remanded for a new trial. And I would say, to answer the more detailed question, I don't really think this court can speculate about which incidents the jury will.
Counsel, I'm going to have to ask you to wrap up.
Yes, Your Honor. For all the reasons we expressed in our brief, we would ask the court to reverse and either vacate the convictions or remand for a new trial. Thank you.
Thank you both for your presentations. The court will take them under advisement and issue a decision in due course. The clerk of courts will mail you a copy of that decision on the day that it is released, and the Ohio Supreme Court will also post it on the website. So thank you again.